Yeah!
Hey, good Saturday afternoon. Carl Rominger here, coming live from the WHP 580 studios. 540-0580, 540-0580. Call in with your legal questions. I'm going to answer anything you want to know. Got something you want to talk about? I was on Durgan the other day to talk about the Arizona law. I don't want this to turn into a whole debate about immigration, so let's not go there if we don't have to. But if you feel compelled, I'll talk to you about it. I was opining to Durgan, and again, the talk line number is 540-0580. I was opining with Durgan that law will not be struck down in the first lawsuit by the federal government, which has to do with the supremacy clause. I don't think that's going to happen. Although to the extent that what a state does could interfere with international diplomacy, it's interesting because if you remember, Texas went ahead and executed somebody, I believe, over the objection of some foreign government, maybe Mexico, and the United States Supreme Court, the federal government didn't have the power to stop Texas from doing that. So I'm not sure how this is all going to play out, but I suspect the first suit will be lost. The suits on racial profiling, et cetera, will be the more interesting ones, and I think that'll develop after it's actually in practice and we get some actual factual cases to bring in front of the court. I don't think they're going to block it just yet. David, you're on WHP 580 with Carl Rominger. My talk line number is 540-0580. What's going on, David?
I have a question.
Yeah.
If, and it has to do with a friend, they're married, they're getting, or they're living together, and they break up, and she kicks him out.
Okay.
And she goes and takes all the money out of his savings account because she has access to it.
He gave her access?
Well, I don't know if he actually gave her, but she knew.
If he didn't give her permission, then it's a theft.
Okay, if he didn't give her a permission originally, or the permission when she took all the money.
Well, that's always the problem, isn't it? I mean, in those cases, it becomes a really he said, she said sort of situation. She's going to say, he said, my money's yours. Remember those famous lines? What's mine is yours, and what's yours is mine.
Correct.
Forever and ever.
Well, but here's the other complicated part. She then put it in her mother's savings account.
Okay.
Is the mother guilty of anything?
She could be if she's conspiring to help her daughter commit a theft. I mean, in other words, if there was an agreement between the two of them. Now, she didn't tell her mother. I mean, she went to her mother and said, "We got some money. I need to park somewhere. Could you do that for me?" There's no crime there. If she said, "I need help because I took this money from my boyfriend, and he doesn't know I have it yet, but when he finds out, he's going to be very angry, and I need your help to hide it." That might rise to a level of a conspiracy or accessory, yeah.
Okay. That's what I needed to know.
Just so you know, by the way, if I'm the police officer taking the police report, I'm going to be like, go get attorneys. This sounds like a civil matter, which is the usual answer you get in the boyfriend-girlfriend split-ups, because it's just too hard to prove beyond a reasonable doubt that she didn't have access to this stuff. And there'll probably be some crazy text message exchanged at one point, which, I still love you. It was exchanged after the money was taken. Who knows? I'm just saying these cases are notoriously hard to prosecute.
But the point is, if she just took the money out of spite, that's theft. And if mom doesn't give it back to the boyfriend, if he asks for it,
she could potentially be a conspirator or accessory.
Okay, and that I'm more worried about the mother than
but for her to be guilty of something, there has to be a theft in the original matter. Okay.
Okay.
So just keep in mind that proving these things is often very difficult, and again, it's probably where a civil action is going to be much more successful.
Okay.
All right, my friend.
I appreciate it. You have a good day.
Yeah, boyfriends, girlfriends, husbands, wives, you certainly can steal from one another. The problem isn't that it's a crime. And I had this guy named Joe on with me at Durgan the other day. And Joe was saying a law is a law, and you have to enforce all laws. And if a law's on a book, it must be enforced, and it's just the way it is. And we're a country of laws. We must take the laws off the book if we're not going to enforce them any longer. And I was trying to explain to Joe that it's not that simple. So if you're the prosecutor, and let's suppose this woman did steal the money, but it's in the context of a boyfriend-girlfriend live-in relationship at 10 years, how do you prove it beyond a reasonable doubt? And so the prosecutor could decline to prosecute under his discretion, which he's, by the way, Joe, allowed to do by law, choose not to prosecute. So just think about that in these domestic situations. Always think civil unless it's a clear-cut case of theft. And again, the problem is, like when we get into the case, and I'm saying I'm the defense attorney, I'm going to come up with some text message that this guy sent this girl 3 days after she allegedly stole the money and they were broken up, where he's opining about how he still loves her and what a great dinner they had the night before and how they should really keep working on the relationship. And then you're saying, well, when did the relationship really end? Is it over? Was the money taken at the end of the relationship when it was clearly over? All those sorts of things. And, of course, you've got all those, what's mine is yours, and why would you give her access to your account if you didn't want her to have it anyhow? 540-0580. Greg, you're on WHP 580 with Carl Rominger. Hey, Greg.
Hey, Carl. How you doing today?
Good.
I talked to you a couple of weeks ago. I have a support hearing coming up in a couple of days here. I have sole legal and physical custody of my 2- and 3-year-old.
Mm-hmm.
I've been told by their mother that she is not going to show up at this hearing. In your experience, does the judgment usually go against her then?
Well, the answer is the only thing that she could help do is verify her own wages, or oppose an argument that she makes more than she does, or assert why she can't make as much money as a person of her normal earning capacity would.
Yeah, what she has done, she has not paid a cent since I've gotten custody, and we've actually had this continue twice now because she was out of state.
Yeah, they're going to have to. They're going to have to set a wage, and so they may just take testimony from you at this point. And so here's a couple of questions, and I'll ask them. Like, I'll be the hearing officer. You're at the hearing.
Okay.
Sir, what did your wife last do for a living?
She was
mother of your children.
Assistant,
What did she last do to make money?
Her last position was an administrative assistant.
And how much did she earn there?
Close to $40,000 a year.
Did she ever have a job that paid better than that?
Not to my knowledge.
Okay. And how long ago did she stop working in that capacity?
October 2009.
Okay.
She's
Well,
not worked since then.
What we'll do then, sir, is we'll hold her to $40,000 a year, and we'll calculate the support as if she were currently making that, absent any testimony from her. And then the support officer turns to the empty chair and says, I noted once again that she's not here, so that's the number we're going to run with. Now, if she was there, she might be able to say, well, here's why. I got my company went bankrupt, and I couldn't find a job, and now I'm on unemployment, and it's been extended indefinitely, and I intend to collect it for the next 47 years. So I'm only making $360 a week.
Okay.
I mean, but she's not there, right? So your testimony is probably going to become what controls.
Okay. The second part of this is there's a very good opportunity that she'll probably be incarcerated this week. Does that have a bearing on this as well?
It does, because if she's incarcerated, they're not going to anticipate that she's going to be able to pay any money to you.
Okay.
And they may suspend the order during her period of incarceration.
Of course they will.
Well, you know what we used to do? See, and you got to understand this. I mean, people get upset because if somebody's incarcerated, why would we suspend the order? But what would happen is, guy goes to jail for 6 months. He stops paying his child support. The order didn't get suspended, and we would say he's 6 months in arrears, and then we would spend all this money on child support enforcement, forgetting the reality being that, realistically, he's not going to make that 6 months up easily, and we're going to spend all this money on enforcement and all this sort of stuff. So they kind of said, finally, let's still be more a little sensible, and if somebody's going to be locked up for a year, we're not going to assume that they're earning wages and not paying them.
Right.
And we're going to treat them a little differently. It's not fair to the kids. It's not fair to the spouse, but it does save the system some hiccups. On the other hand, if they're on work release and making money, then they're going to be held to that.
Okay, my issue, she has 4 warrants out of 3 different states. And it's coming down on her pretty quick here, so I'm afraid that might happen this week.
Well, once one gets her, they'll all share.
Right, I understand.
And she gets to ride a little prison bus.
And about 7 states away, and that's where the most serious offenses have occurred.
Yeah.
So I'm not looking at much happening here, but I appreciate your time.
Hey, Greg, thank you very, very much. Take care. 540-0580, Carl Rominger here. Weekend Appointments, the show, answering your legal questions. I'll see you after the break. Hey, welcome back. Carl Rominger here, answering your legal questions. If you don't know me, I'm an attorney here in the Mid-State, practice a little general practice of law. Get to go to criminal court once in a while, do a few trials there. Did a couple death penalty cases over the years, which were very interesting. I actually represented a chief of police who had gunned down his wife, which I guess I can't say allegedly anymore because he was convicted of that, which, of course, I always love to point out to district attorneys when they accuse me of saying, well, why are you saying the police officer would lie? And I'm saying, well, I'm not saying he's lying. I'm just saying that they're human beings and everybody's kind of in the same basket, whether you're a police officer, an attorney, or I don't know if I should comment on this. Somebody told me I get in trouble if I brought it up. I don't know what they meant by that exactly, but I'll let you figure it out. I noticed in the news that one of our state senators and her sister, who happens to be a Supreme Court justice here in Pennsylvania, were using a clairvoyant to foretell the outcome of their efforts to head off a grand jury investigation in Pittsburgh. So if you've been following the Jane Orry, Senator Orry, whatever it is out there in Pittsburgh, I'll encourage you to look it up on the newspapers and see what it has to say. But it's another one of these political corruption style trials, and it's kind of interesting because this came out that they were consulting a clairvoyant, and I thought that was just kind of the thing that makes you chuckle a little bit, because I don't think that's going to help. 540-0580. Dale, you're on with Carl Rominger. Hi, Dale.
Oh, hi, Carl. Got a question for you about a bill collection. I have a bill that it's well over the statute of limitations. It's like, I think it was from 2002.
Okay.
They've never contacted me till just recently, and then they've been contacting on a regular basis. Now, I know the statute of limitations. I've been ignoring it. They've sent me several letters stating, hey, we'll give you a settlement for $100 on it. And then they gave me a settlement for like $50. Now, my last letter said they'll give me a complete settlement on it for $25. Now, the question I have is, if I pay that, can they come back and say, hey, he made a payment on a bill that...
No, if in fact they say in full settlement, but here's what you're going to do with your check when you write them the $25 check if you want to just get rid of this issue. You're going to write full satisfaction and accord. Okay, that's ACCORD, accord. Full satisfaction and accord. You put that on the memo line, and those are magic words. If you cash that check and there's a dispute as to an amount owed or you're pursuing somebody, it seals the deal absolutely. Now, you would have to put that on your check, and you could still argue that you paid and they made an offer, but those are magic words on a check's memo line that can kill a debt absolutely. And for the idiots out there who are going, aha, I'm going to send that into JCPenney's right now on my next $15 payment on my $1,000 bill, if a person is a retailer who mechanically sorts checks, they have 120 days to catch that. Okay?
But like I said, because I mean, I thought the statute...
Well, they can't pursue you anymore, and you might be able to do some things to them. You might want to go after them with a nasty gram, or you might want to do a Fair Debt Collections Practices Act dispute. You might want to do a lot of things, but for $25, it's probably the cheapest way out of it.
Cheapest way to just get rid of it and be done with it.
Yes, sir.
Okay.
All right. Take care, brother.
Full accord.
Full satisfaction and accord.
Full satisfaction and accord in the memo line.
Yes, sir.
Thank you.
All right, brother. Take care.
You too.
540-0580. Carl Rominger here, answering your legal questions on WHP 580. Ryan, you're on the air.
Hey, Carl. Big fan of your show here and the 580 in general.
Thank you very much.
And love listening to you talk on Durgan's show. So, with this recent event in the news this week, with the Carlisle shooting at the firing range,
yeah.
You're familiar with that, right?
Oh, yeah, very familiar.
I know you're a big firearms enthusiast, as am I myself, and I was just wondering if you could tell us your thoughts on that.
You know, and I actually had the chance to think about this a little bit, and obviously it's the talk of the courthouse and, you know, the prosecutors and the defense attorneys and everybody. And obviously it was an attorney who was shot who was a civil attorney and well known to many of us in the bar as well. And my thought on the matter is I'm always suspicious that somebody really wanted that gun. The thing that struck me, and it's funny because it's lost on some folks, but it's a .308. And if anybody out there knows anything about the .308, it's probably the most studied round in the history of the world because it's the original sniper round for all intents and purposes.
What, did he have, like a Remington 700 or something?
It was a AR-15 that had been in a .308.
Oh, like a I see.
And
that's an unusual chamber. Aren't they usually in like 223?
That's correct, and that's a fact. A couple of people thought it was 223, but it was a .308. So then you add the suppressor, or as we call them, we call it a silencer, which the real purpose of is not really to reduce the noise so much as it's to increase the accuracy of the gun. If you have a very accurate .308 with the right attachments, I think I've seen some people say it's a weapon's effective out over 500 yards. I'd argue it's probably effective out at 1,000 yards if you have a good enough shooter with it. So it's a kind of valuable gun, and it's hard to come by in a way that nobody would know about, particularly because of all the paperwork that has to go on the suppressor.
Right, the stamp for the. I know some guys that use the cans just because that's a really loud round.
Right.
With or without ear protection.
Right, and so that's the thought being is somebody might have sought, but it's going to turn out to be one of three things. It's going to turn out to have been somebody sophisticated enough to recognize the value of the weapon for illicit purposes. It's going to turn out to be some drug-addled teenager with a crime of opportunity who just thought the gun looked cool and is going to try to sell it for $15 in an alley somewhere. Or it's going to turn out to be, completely unrelated to the gun, and the disappearance of the gun's just a red herring. Because it wouldn't be, if you ever watch Law and Order, right? Let's use Law and Order as an example.
Sure.
They always got some guy who's got the dead guy's credit cards, right? And they collar him for the murder, but he quickly switched, "Oh, I didn't kill nobody. Whoa, 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 I just stole the credit cards."
Right.
And so, the next question is was the person who found the body the first person to find the body, or did somebody come along and just see this nice gun laying there and unaware that there was a body somewhere? And that's always the other explanation. Of course, when it's something like that, then the gun just turns out to be a complete red herring.
I had one particular question on this, which leads to a second one if you have time. One was somebody on Durgan's show this week called in and said that most gun ranges have the rules that all firearms have to be left at the bench with the action open and no rounds in them, typical gun safety laws. But the caller was saying, is it legal with that posted to bring something concealed carry down range with you, like a little, 380 or something?
If you're the game commissioner, you're going to say no. If you're Carl, you're going to say what's concealed carefully out of view probably will never be seen unless needed.
Right, and that's my opinion too. I'd rather be kicked out of the range than shot with my own gun. But that's really unfortunate. And the second question on that is, what if there is an accidental discharge or like a negligent shooting of types at a range? What's the legal implications for that? Would that be treated the same as an intentional shooting?
The short answer is, and I'll give you an example. I mean, let's say you did accidentally shoot somebody at the range. It's going to be involuntary manslaughter at best. It could be voluntary manslaughter, which is, but probably not. So it's probably going to then fall into because that requires specific intent. So you're probably going to end up in third-degree murder if you did it with reckless indifference. So if I'm just trying to think of all the ways it could happen, and you can imagine that if somebody was simply decided to start shooting openly while people were downrange and wasn't trying to hit anybody but did, that's probably going to end you in third-degree murder. If, on the other hand, you're back at the bench, you're setting up, and you don't realize that there's somebody downrange, and you haven't taken, he's behind the target area for some reason, digging around in the dirt for old bullets or whatever people do. You don't realize he's there, but should have realized he's there at some point, then maybe it's involuntary. But, of course, if you flee the scene and you're not found there and then later it's tied to you, obviously that's going to open you up to you must have known you did something very wrong or else you wouldn't have fled the scene. And, of course, a guy like me is going to argue, you just panicked because people do panic.
Right.
I've had the opportunity. Oh, go ahead.
Oh, I'm sorry. I was just going to say I see plenty of range time myself, and I've never heard. I know this probably happens more often than I hear of it, but if something like this did happen, accidental or intentional or anything, it's just good to know the legal implications. Because I've seen actually while I've been at the range some rounds go off that fortunately nobody got hurt, but somebody forgot they had one in the chamber, or
right.
Like the state game ranges have the 3 or 5 round limit
right.
before you can go and take down your targets, and somebody will go in there with a clip bigger than 3 rounds and have it fully loaded, forget that there's one in there, and then all of a sudden a round gets squeezed off when somebody's downrange taking their triggers down or their targets down. So
right.
In that case, if there was an unintentional discharge and nobody got hurt, is that something that needs to be reported? Or is
Well, okay. The answer is that's up to you. I'll go by an analogy right now. I have a client who's having a dispute with another guy, and the other attorney called me up, and he's like, I don't know, my client decided to call the zoning guy in to check things out, and of course now the zoning guy's giving him a hassle about his own operation. So, some of us have a theory that don't invite the government if you don't have to. The flip side is you might. I mean, was it a real mistake? Is it something you could correct? Is it a teenage kid who needs a good talking to? Is it a hoodlum who needs to be reported? Could it be charged as a misdemeanor reckless endangerment? The answer is probably yes. So, I mean, anytime a firearm's discharged accidentally in a house, I know the state police almost always charge reckless endangerment, amongst other things.
Even with no injuries.
Correct.
Yeah.
So.
Oh, that's the opinion I have, is that it's always a negligent discharge. There really should be no such thing as accidental.
And the answer there is, I mean, as I told someone, it's easy because all guns are loaded, right? I mean, you just handle them all the same way. So I never understand why somebody goes, "Oh, I didn't know the gun was loaded," because, well, if you're handling it like it's loaded, it doesn't matter.
Right.
But hey, I'm going to let you go. Take a few more callers. I got to go to break here in a minute, Ryan.
Thanks.
All right, take care.
See you.
540-0580. When I get back from the break, I'll talk with Chris and Audrey. Hey, welcome back. Carl Rominger here. I'm going to take a few more calls. 540-0580. And, of course, remember, folks, if you can't get through right now, because I know the lines are tied up, well, they won't be for long, but if you can't get through, it's 540-0580. And we keep taking calls from about 3 till 3:45. I go off the air live, but I continue to take calls for the bonus podcast edition, which, of course, you can listen to later. If you don't call in for it, just go online. You can go on my Facebook page to find it. You can go to WHP580 to find it, and you can go to weekendappointment.com to find it. And we have this hour plus the bonus hour recorded for you, and you can keep calling. So if it gets to be 3 o'clock and I haven't gotten to you yet, or you want to call in, just keep calling between 3 and 3:45, and feel free. Last week we had, 10, 15 callers during that time, so people are catching on. So just remember, 540-0580, and keep calling all the way up to 3:45. Audrey, you're on with Carl. Hello, Audrey.
Hi. Quick and to the point. What is the difference between a power of attorney and a durable power of attorney?
Well, interesting question. A power of attorney could mean a durable one or a non-durable power of attorney. But if a power of attorney does not have the word durable in it, it's not durable. And the word durable only means that it survives incapacity. So if you lose your marbles, go nutty, are in a coma, or otherwise unavailable to handle your own affairs, the durable power of attorney will continue to act. And you may say, well, why would I want to do that? Well, what's the difference? Well, I might give a non-durable power of attorney, for instance, to Shane. And I figure as long as I'm alive and well and looking around and know what's going on, Shane can't cause me too much harm, but he can carry out some business for me with it. Mm-hmm. But if I become incapacitated, I never really trusted Shane. He's kind of got a lot of big tattoos and stuff on him, and he scares me. So I want to keep my eye on him. Uh-huh. So if I'm no longer around, or I don't mean dead, I just mean no longer competent, or in a coma, then he can't transact affairs for me anymore. Also, the durable power of attorney has the advantage of lasting through incapacity, so that when I give it to my son or my niece or my brother or my wife, they can help me through my periods of incapacity, and they don't have to go to the courthouse and spend $1,000 or more to get a guardianship. So that's the long answer to a very simple question.
Okay. Well, yeah, that does help. Thanks a lot.
All right, Audrey, thank you.
Bye.
Let's see, who's next here? Chris, you're on WHP 580 with Carl Rominger.
Hey, is it me? I'm guessing. I got a question for you about custody order.
Yeah.
Now, my ex had custody full-time while I was taking care of the boys. They lived with me for 2.5 years. It was still in her name because of the price to get the custody order turned over. Mm-hmm. Now, I'm finding out that she's letting them roam around an area which I don't deem is very good to let children roam around. The oldest is 12.
Okay.
So, and they're out later at night, and there's no supervision. I want to bring them back here. Now, with me having them for 2.5 years before, will that come into account when it goes to court?
Yeah, it will. It will. Also, what you've done in the meantime will come into account as well. And the judge will take all that into consideration, as well as any other information you might have to add. Like, for instance, Mom lets my 12-year-old, hang out on the street corner.
Well, I'm wondering if I should go down and video when they're out roaming for any sufficient evidence, because then it comes to my word, her word, and I know how that can turn out bad for the guy.
Yeah, you might want to take a friend or two along to help you out with that. And, of course, if you catch him out roaming, you want to, send him packing home while you're at it.
Well, I would. But now my next question, her residence is with her boyfriend. There's one bedroom. There's her boyfriend, and the two boys.
Yeah.
Now, will that come into effect?
Absolutely.
In my house, they have their own bedroom. They have their own space.
You're not going to lose custody because you're poor, and you're not going to not get custody because you have modest means. But certainly when a court's trying to sort out where people are sleeping, if you've got one bedroom and 4 people, we have a real concern about who's sleeping where. And so, yes, it will come into concern. It will come into play.
Sleeping on the floor.
Yeah, that will come into play, absolutely, Chris.
Okay, now, I forgot what my last phrase was. All right, that should pretty much cover it.
All right, it's well worth it for you to go to custody court based on what you told me.
One more quick one. Now, the original custody order is through a different county that neither of us live in. We both live in the same county now.
You now have to get it transferred between counties. So you would file a petition in the county where it is to have it transferred to the county where you're at, and a judge would determine whether to release jurisdiction or not. But they should, based on what you told me.
Court for that, for the paperwork?
It would be the Prothonotary's office, and they might have paperwork, but they probably don't. You may have to actually generate your own.
All right.
That's what guys like me do for a living. We write this stuff. All right, Chris, thanks.
All right, thanks.
Bye. Let's see here. Did I get... Okay, who's next here? I'm confused. Chris didn't fall off my screen right away. Al, you're on WHP 580 with Carl Rominger.
Carl, how are you?
Good.
Good. I have a couple of questions. I've got a support and a custody hearing next week. One question I had was, this is like the third, I guess, support hearing I've had, and I now pay $351 a month. Now, after 11 years, I was just laid off, and so I'm getting unemployment currently. I guess my question to you is, I've had a number of emails from my ex saying, hey, the kids need shoes, the kids need this, they need that, and I bought a lot of that. But after a while, I started saying, look, where's the $351 a month that I'm paying you going? And if, you don't want to show me that, then, hey, I'll pay for all their stuff. You go ahead and, I'll stop paying my $351.
Yeah.
I'm not saying I would cease it, but saying, hey, kind of, give me a break on this.
We don't require an exact accounting for that, and in fact, the support guidelines actually anticipate that the payor will still be buying things for the kids during their periods of custody, et cetera, et cetera. Nonetheless, certainly you don't have an obligation to give her any direct payments in excess of that amount. And usually what I would recommend to people is just go ahead and buy the kids what they need while they're in your custody.
Right.
Rather than giving them cash.
I have joint custody right now. I have them, half of the time.
Right.
And so, I guess my question then would be, okay, so when I go into this hearing, just show them a bank stub saying, here's what unemployment pays me every 2 weeks currently. And what else should I bring?
Well, depending on the county you're in.
Cumberland.
Okay. You're going to be going in for an informal hearing, and I would assume you would want to also maybe show what you've done for effort to find a job, because the assumption would be that you may be able to earn more than unemployment, and she's probably going to say that you're just sitting on your keister, right? And you're going to say, no, I just don't have a job available to me right now.
Right. Well, yeah, my company laid off 26,000 people.
Yeah, and that's a pretty good argument. And that's the other good thing. I say good thing. Let me retract that. But the good thing is if you are laid off by a major employer who's laid off a lot of people, you won't be the first person that the hearing officer has heard this story from, and they kind of know really what actually happened. When you work for like a small contractor and the 3 guys, we never know if you were actually laid off or still working under the table.
Right.
So you should be fine based on that. But, yeah, you do want to just show that you're doing something or making some plan for a new job, because sometimes people want to hold you to an earning capacity if they feel like you're willfully not out there trying to get a higher wage.
Right.
But it's no fault of your own, so they should use the unemployment as your wage for the moment.
Yeah. Well, my second question is, then she had filed for she wanted primary custody.
Right.
And now for the last year and a half, we've had split joint custody, and I picked, since I was unemployed, I picked the kids up from school every single day, and this has gone on for a year and a half, and all of a sudden now she moves. She moved into a lot nicer house, and my kind of thought process here is, well, she was cheating on me with a neighbor, and it may be this guy's house. I don't know.
Right.
And so I'm sitting there going, I'm paying, as much as I can afford, and it's gone on for the last year and a half. The kids have, somewhat adjusted. There have been no problems with that. All of a sudden now she comes at me with, now she's going to try to, in my eyes, take the kids. What do I need to do, or what do I need to show?
Basically just need to show that the kids are doing well under the current circumstance and that it's in the children's best interest for it to remain. If, in fact, that's been the status quo for a while and they're doing okay, the burden's going to be on her to change it. But what you're asking is something that usually I would meet with a client for a couple hours about while we go through all the facts of their specific case and determine, what we'd want to present in court.
Right.
So, but the general rule is, as long as things are stable and the kids are doing well, the horse ain't broke, that old saw. And that's kind of how the law looks at it. Now, that said, obviously there's certain things she could be doing to angle, and like you say, she's trying to pad, nicer house, this kind of thing, and say, well, that's a change in circumstance, Judge. But the reality is, again, if the kids are doing well in school, and I said this to a caller earlier, we're not going to deny you custody just because you don't have the best house compared to the other side, or even split custody. So, but Al, if you want to talk to me off the air, just go to weekendappointment.com and you can catch my contact information on there.
Okay. Well, thank you so much. I appreciate it.
All right. Take care, brother.
You have a great day.
I got to go to break here. I got Angela and Randy holding, and when I get back, I do want to talk about a newspaper article that someone posted on my Facebook page and want to know my thoughts, and I promised I'd talk about it here on the air. 540-0580. See you after the break. Hey, welcome back. Carl Rominger here. I just leafing through my Trapper and Predator Caller magazine. I finally got my membership updated with the Pennsylvania Trappers Association, and my magazine's just arrived. Of course, how that works. When your subscription kicks in, you get 2, so I got to catch up now. So 540-0580. I want to talk real quick before I take some callers. And, of course, remember, you can keep calling from 3 to 3:45. So if you're on hold now or if you're planning on calling, you got all the way up till 3:45 to get a hold of me, and we'll answer your questions in the bonus podcast hour if we don't have time here on the air. There was a Lancaster news report about a New Jersey DUI case that could affect Pennsylvania because our law is very similar. It involves the informed consent law, and apparently it was a non-English speaking individual who was read that warning that you get read. And here in Pennsylvania it works something like this. You're told you can't refuse the blood or breath test, and if you then refuse, you lose your driver's license, which is completely independent of the DUI charge. So if you haven't been drinking, you've done nothing wrong, but the police pull you over for some reason and ask you to submit to a breath or blood test, and the officer has any reasonable basis that he can articulate to believe you've been drinking and driving. So, I don't know, he says you saw you leave the bar, and he thought he saw you stumble once and in the car. Whatever he can articulate. Doesn't even matter if he actually saw. As long as he can articulate something, you're going to lose your license if you don't submit. And this comes up because every once in a while I get some poor sucker who hasn't been drinking, hasn't done anything wrong, and gets asked to submit. And, of course, they're indignant and saying, I'm not going to submit because, well, they read you this warning. And the warning says you don't have the right to refuse per se. You don't have the right to have a lawyer. You don't have the right to have counsel. And they read it to you in English. And in New Jersey said, you got to if you're going to take the person's license away, you got to give them the warning in their own language, or at least one they understand. And, of course, on my Facebook page, you can follow the thread here. Somebody just posted along the lines of, well, if they took driver's ed and took the test and they can read the manuals and get their license, they should already be able to understand what's going on and know the laws. And that's not really the issue per se, because even if you're an English speaker and you've read the manuals and you've passed the test, you still get that warning on the site. And part of the reason for that is because sometimes it might seem really unfair or inappropriate for you to have to go down to the station and blow in that little machine or consent to have blood taken from you. Believe it or not, getting blood taken can actually be dangerous once in a while. There's complications. You could get an infection. You could get a clot, which could turn into a stroke or a heart attack, and you could die. So, I mean, just to say it's no big deal is not enough. So the legislature has said that. And, of course, that means that you as an English speaker, if you're an English speaker, are going to get your warning in English. And the New Jersey Supreme Court said, hey, everybody should get it in a way they understand it because everybody's entitled to this warning. The legislature's spoken. So it's not a question of whether you know the language or don't know the language. It's just a question of whether or not you're going to get the warning or not. And we're just not going to take your license away from you for refusing if you weren't warned, English speaker or non. And, of course, if you're not an English speaker, I mean, what if the guy's deaf? Does that mean that the police officer is just allowed to say it out loud? Remember, you can be deaf and drive. It's potentially illegal. So can the police officer just say it out loud and go, well, I gave it to him in English, and he didn't. He refused. So that's the idea there. And if you want to follow it, just go to my Facebook page. If you don't have access to it, just friend me, and you can talk with us on it on there, and we'll go from there. Who's next? Randy, you're on WHP 580 with Carl Rominger. Hey, Randy.
Hi. My question is about a trust fund that was set up by my father-in-law for my children and the children of my wife's siblings.
Okay.
And I forget exactly the amount. I think there might have been $10,000 or $15,000 put in. It was different for some of the grandchildren than others for a couple of silly reasons. But what responsibility do the trustees have to communicate to the trustors how that money is doing? Do they have any responsibility whatsoever?
I would think that they do, and I would think that at least annually it would be worth letting them know. Now, quite interesting, of course, what's the duty of the trustee? And the answer is, I think, a fiduciary duty to manage the money, although they don't have to be right. A fiduciary doesn't have to be right. So, if you put the money in the bank and the bank defaults, well, it's not your fault that if the bank defaulted. If you put it in the stock market, I mean, obviously you shouldn't be putting it in risky things. So the trust itself, however, usually will have provisions that talk about what the trustee can and can't do with the funds. And so as long as they're doing what's allowed by the trust document, then it would seem to be okay. The trust may also have a stipulation about, keeping the beneficiaries in the blind.
Oh, really?
And there might be a reason for that, because sometimes, particularly if you're trying to leave money for kids, the more they know about it, the less likely they are to get off their butt and do what they need to do.
Right. No. I mean, the kids were, all the grandchildren were told how much money is there and that they can get it at 35. I mean, that was the provision. Once they turn 35, they can get the money.
You just wonder what's happening with it in the meantime.
Yeah, I mean, they were curious just to see how this money is invested. And I do know that for some of the trustors, some of the grandchildren, the money was taken and put places other than where some was taken for the others.
Yeah, interesting.
In other words, some of them, I mean, my kids' money is stayed with whomever they had it with, and I don't want to say on the air who that
right.
was. And then for a couple of the others, they took the money and they put it with another private investment, an investment advisor.
I guess the short answer is what you'd want to do is go to the trustee and maybe get a copy of the trust document, and then just get a history where the money's at and how it's doing. And if they refuse, I think ultimately your right's to go to court, because that's where those matters are enforced, in the orphans court.
Right. Okay.
All right, Randy.
Hey, thank you much.
Thank you.
Bye.
540-0580. And, of course, remember, we'll keep taking your calls up till 3:45. Kurt, you're on the air.
Hi, Carl. How are you?
Good.
Hey, sir, here's my question. I stumbled onto buying a .com that deals with the car business of a major European car dealer, or a manufacturer, I should say.
Okay.
And its ranking has become like number 1 on Yahoo, I'm number 4 on Google, and I realized this name had some value. I went out and emailed some dealers, and I was then contacted by a hotshot attorney out of D.C. threatening to sue me for cyber squatting for $500,000. And I'm curious, there's a lot of these sites on the internet. Is this a scare tactic? I didn't go to the actual manufacturer and try to sell it to them.
Right.
I just went to car dealers realizing that this would help their sales.
Well, there is a law. There's a federal law in place that deals with cyber squatting, and it's pretty harsh if the court, in fact, determines that you did cyber squat. I'm trying to remember what the I think it was called the Anti-Cyber Squatting Consumer Protection Act or something. It was back in the late 90s, maybe early 2000s, somewhere in there. But it has to do with distinctive trade names, personalities, etc. And so, I mean, it is pretty harsh. What I would tell you to look up is the Anti-Cyber Squatting Consumer Protection Act. And you can see...
My quick question, I'll let you go.
Kurt, hold on. We'll take you in the bonus hour here.
All right.
Folks, keep calling, 540-0580. Keep calling. If you're busy, just keep trying from now till 3:45. Otherwise, I'll see you next week. But again, during the bonus podcast hour here, we're going to keep the phone lines open until 3:45, so you can keep calling. And, of course, don't forget to go to weekendappointment.com and claim your free will. See you next Saturday.